this webinar called Faithful Stewardship, a webinar on estate planning hosted by the Center for Christian Studies. So it's good to see everyone who's participating and those who will be joining us for this. We're joined tonight and leading this webinar, joined by Steven McClelland, who is the owner and the lead attorney at McClelland Law Firm. And he is himself a certified elder law attorney. So really an expert on estate planning. And this is just a great thing that he's doing for us. And it's sort of a win-win for, I think, everyone who's able to have a look at this, because he is giving out for this some just complimentary advice on issues that I think we all should be thinking about. And that is how to bless others with the blessings that God has given us. So we're really happy to welcome Stephen. In just a moment, I'm going to turn it over to him. But the way this is going to go is that he's going to simply present on these issues for about 22 minutes or so. And then at about 5 till, I'll take it over again, and we will invite questions from those who are participating here. So if you're participating, please keep yourself muted during this, and write down any questions you have, because it could be that he's going to answer those questions. But if you've got questions that you want to ask and they weren't answered, or you want to press for more details, we're going to have 5 or 10 minutes at the end of this. Stephen has agreed to stay and answer a few questions. So with that, I'm going to turn it over to Steven McClelland. Thank you so much, Steven, for joining us for this webinar.
Yeah, absolutely. I appreciate it, Keith. I'm going to cover a whole lot of material this evening, and I hope that hope it really helps clarify a lot of things. It's not uncommon for a lot of folks to meet me in my office and say, I have no idea where to start. So we're going to go basic, but also some more complex things to talk about. So first, faithful stewardship. This is probably the group that knows that you can't take it with you, right? It's got to go to someone. And we're going to talk about the best ways to do that, things to consider. So for the overview of this seminar, I have 6 things to talk about, a whole lot to get through. I'm going to talk a little bit about myself. Step 2, I'm going to talk about what Jesus actually said about estate planning, kind of a surprise thing there. We're going to talk about goals versus documents. I'm going to tell you why I think goals are more important than documents. 4, I'm going to tell you the 4 biggest mistakes I see people making every single day. I get calls about them. I don't even kid here. I just see these mistakes over and over again. 5, we're going to talk about charitable giving. We're going to talk about the kind of the best ways to do that. I think that's a big part of our faithful stewardship, is thinking about charities and how we can have a lasting impact, not just on our families, but on the kingdom. And then some bonus material and question and answer at the end. So starting with a disclaimer, of course, you have a lawyer, right? You expect that. I just want you to know that this is for informational purposes only. It does not substitute for legal advice. Now, obviously, I can't practice in every single state because we have state bars, but so this is based on Arkansas. So I'm not really saying, well, this is what Texas says or California, just keeping it general. I'd love to have an attorney-client relationship if you live in this state, but if not, I don't want to leave you without a good resource. And as Keith mentioned, I am a certified elder law attorney. I think that is the gold standard of someone who knows estate planning and knows the issues of growing older. So there is a database, the CELA database, CELA database. If you're looking for an attorney in another state, that's where I would go. I do this all the time when I have a client that has a deed in another state. I'll go to the CELA database because those are the ones I think who really know what they're doing. There's like a special test we have to take, and we have to practice for a certain number of years. So if you're ever watching this and you're from another state, that's where I go. There's only 4 of us in Arkansas that are C-list, so it's not a very common it's not very common. So all right, so a little bit about me. This is myself and my wife Mindy. Here we are flying. I'm a private pilot. That's what I like to do for fun. We are flying west here in the evening to go to dinner at a state park. And so that's kind of why we're squinting there. We don't fly very much together, but this was one of the few occasions I cherish this picture immensely. And we have 3 daughters. And from left to right on my screen, that's trauma, drama, and crisis. So those are them. If you know them, you know I love them. It's just a ton of work when it comes to raising daughters, raising kids. Estate planning is all about family. That's why I put my family here, but it also hits you when you're flying, you travel, you think about your estate plan. I know I always think about it when I take off and when I have some other pilot fly me, you just kind of hit you on the runway. How is everything if I went today? So we're going to talk about ways that you can travel with peace of mind for you and your family. So a little bit about my firm. I have 4 offices in Central Arkansas. I live in Searcy. My wife teaches at Harding. We met at Freed-Hardeman University, and we came here because she started PA school at Harding, and I was in law school at Faulkner in Montgomery, Alabama. And I transferred law schools and married her and had the kids and all that. And the reason I've grown the firm is because I was under the shadow of an elder in the church who did estate planning and took me under his wing. And he passed away at 65 with a rare form of cancer. And that really hits me because none of us are guaranteed any set amount of time or retirement. We just don't know. But that's kind of, I pay tribute to him. That's really kind of how I've been able to have the practice that I do. And we are just focused on estate planning, probate, and elder law, things related to last wishes. So what does Jesus say about this topic? All right, I'd like to start there. When I went to Freed-Hardeman, I got a degree in Bible and accounting, so I'm going to use that here. Talk a little bit about Luke 12. Verse 13, someone in the crowd says to Jesus, "Teacher, tell my brother to divide the inheritance with me." I hear this all the time. I mean, this is a real thing. I hear it all the time. And Jesus replies, "Man, who appointed me to be a judge or an arbiter between you?" And then he said to them, "Watch out, be on guard against all kinds of greed. Life does not consist of the abundance of possessions." Jesus here saying, I don't want to be a probate judge. And I told that to our local probate judge. He said that must mean that I'm entitled to a few extra stones and jewels in my crown if I'm willing to hear all these probate arguments. So Jesus is kind of against probate, doesn't really like it, and I'm kind of the same mind. I don't want things to be a mess. I don't want people fighting when you're gone, and writing things down, I think, does wonders to alleviate that and make wishes carried out. So I think goals are more important than documents. I'll say that again. Goals are more important than documents. The reason I believe that is people call my office and they say, "I need this document." And we ask them why, and they say, "I don't know. I was just told I need this document." So I like to draw a distinction between legal documents and legal services. You can get legal documents online, but legal services is an attorney that's helping you figure out what these documents actually mean, which ones are appropriate, and all the nuances in those documents. And you can't replace that. And I like the focus of planning, not documents. That's what people really want. So I wrote down a bunch of goals here. You can screenshot this. You can write some of these down. There's a lot. This is not an exhaustive list, but I did want to pick up the 8 most common ones that I hear in my practice. First, avoiding probate, like the Luke 12 quote. People say, "I went through probate with my parents," or "I hear it's awful. I don't want to go through probate." I hear that all the time. The second thing is people are concerned about the nursing home. They know it costs $8,000 to $10,000 a month. And if you're there for a year or 2 years, that's $200,000. How am I even going to leave anything to my family if everything goes to the nursing home? People are concerned, what if I'm unable to pay my bills or talk to doctors. This is particularly concerning to me because the men in my family have strokes. They all have strokes, right? And overnight, what if I can't pay the bills? Who do I trust to handle that planning? Well, for most of my clients, they're 60 and above, so they don't have minor kids, but some of our clients are 30s and 40s, and they do want to have a guardian in case something happens. And charitable giving, very, very important thing. Talk a little bit about that at the very end. Spendthrift. Hey, if you got a kid who's not good with money, how do you protect them so they don't blow it all, right? Generally, it's best to give money to them when they're responsible enough. I have a saying, I think all 18-year-olds to 24-year-olds should be broke. They shouldn't have any money. They should work. They should work. They should understand the value of a dollar. If you gave them 20,000, they would believe they're set for life. It just doesn't work that way. It's best to spread that money out, half at 25, the remainder at 30, but maybe give it to them earlier for college, trade school, that kind of thing. It's important to name a trusted individual to carry out your wishes. Y'all saw I had 3 kids, and I can tell you right now, my oldest is the one who's going to be in charge. She is by the rules. She structured. She's just a rule follower. My middle one, love her, but she is kind of wild, right? She has a big heart. I love that about her. But a lot of parents just know from the very beginning who they trust because they've seen a life of their kids, and they kind of know how they're I don't know how we're slanted, how we are, right? And lastly, most clients just say, hey, look, I just want to make it as simple as possible. These are the most common goals I see in my practice. I want to talk about the documents now, okay? So I think documents fall into 3 categories: planning for incapacity, death, and elder law. What I want you to know about incapacity is we do a financial and a healthcare power of attorney. Sometimes maybe one child is an accountant and one's a nurse. So the accountant is the financial power of attorney and the nurse is the healthcare power of attorney. Very common. And here's a tip. I say this, I don't know why more people don't think like this, but most people say spouse first and then my most trusted kid. And that works great when you're 60. But for 70-year-olds, I often say, let's name spouse or trusted kid on the first line. Because if mom and dad get sick at the same time, really it's that trusted kid who's taking care of everything. So that's just kind of a tip. So maybe in your 60s, it's spouse, then kid. But when you get to your 70s, you kind of move a kid up so they're on the same line as mom and dad. Now, I mentioned a living will here. I just want to say I don't think it's the most important document. I know when you're 65, your Medicare well visits, they ask you, do you have a living will? Do you have a living will? You have surgery, they want the living will. It's not that important of a document. It is, but it isn't. It has to do, most of them say, hey, if I have an irreversible condition and I'm brain dead, pull the plug. I don't like ones that are very specific about feeding tubes, ventilators. I don't like that. I prefer a healthcare power of attorney to make those decisions. Okay, let your family talk to doctors and figure out what's best. So that's kind of a tweak, I'd say, between the healthcare and the living will. I think healthcare is more important. Okay. Side note here, if a doctor says you're incapacitated, you can still do a power of attorney with an attorney. All right. Doctors always say people are incapacitated, but really an attorney is the one who makes that determination. Okay. So there may be situations where they say dad isn't capable of signing his name, but maybe he is for legal purposes. You never know. When it comes to dying, 3 things: beneficiaries, wills, or trust. So the pros and cons to each. I'll tell you right now, I think a trust solves all the goals that my clients have, but sometimes people don't do trust. So if you have a beneficiary on your bank account, like for me, if my bank account said when I die, it goes to my 3 daughters, the bank account typically says if one daughter dies, it's 50-50 to the remainders. And that's typically not what clients want. When I talk to them, they typically say, hey, if my kid dies, I want it to go to the descendants. So sometimes beneficiary designations don't work the way clients really want it to work. So you could have a will. What I want you to know about a will is that if you have beneficiary designations on the bank account, then the will doesn't impact that. So if you have a beneficiary on your home, Texas calls them transfer on death deeds, Arkansas beneficiary deeds, they're ladybird deeds in Florida. If you have beneficiaries, that's where it goes. So the will only covers things that don't have beneficiaries. And I don't like wills because wills have to go to probate. So if you learn nothing, wills don't avoid probate. Wills are just instructions for that probate judge to read and pass out your assets. But for most of our clients, what they want is a trust. They want to protect assets, put it into a bucket, irrevocable or revocable, and keep it out of the courts and have special instructions and maybe give them money over a period of time, not all at once. And that's the beautiful thing of a trust. Beneficiaries, they're entitled to it at 18. So if my kid beneficiary, she gets it all, right? But I can have a trust that says, no, 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 you're not old enough yet. Now, elder law, I don't want to go too deep into this, but elder law attorneys talk about how to protect assets for the nursing home. Typically, that's an irrevocable trust. And the best time to do that is early 70s because the average person goes in a nursing home at 79. So that's kind of a proactive plan to consider there. All right. Here's the mistakes. One, if you don't have powers of attorney, then your family has to get a guardianship. I see this all the time. To pay bills, to talk to doctors, and that's going to be costly. It's going to be $2,000 to $4,000. So everybody over 18 needs a power of attorney to avoid all this mess. Number two, if you rely solely on a will, then you're stuck in probate. Arkansas, it's like 7 to 14 months, $7,000 to $12,000. It's a big, big pain. And the problem is probate cases have increased over the last 10 years in Arkansas. We have had 10,000 probate cases a year. That's a lot. I think it's around like 17% of the third. We have 33,000 people die in Arkansas every year, 10,000 probates. That's a lot. Okay. So it's not decreasing. And I think that is because there's a lot of do-it-yourselfers that don't really know that a will requires probate, and it's more complex than ever. People have assets in a lot of different places. So I think also we as estate planning attorneys have done a really bad job of telling people about wills and their limitations. We haven't done enough, obviously, in my state. Okay. Third mistake, just failing to list properties. So I have a list here. Best thing you can do is just go home and write 2025 and list all your assets. Because if your family can't find it, well, it's basically going to go to the state. So you got to make sure things are written down. Life insurance, if you don't request it, they're not sending you any money. So you've got to make sure your family knows about that. Even those $10,000, $50,000 policies that were paid up years ago, that will save your family hours of searching for those documents. Because you don't want your kids to have to spend hours going through boxes and drawers. This has nothing to do with estate planning. This is just, you don't need me to do that. Just make sure you write those things down. And it's good to videotape your house in case you ever had an insurance claim like a fire or a tornado. Just take your video camera, go through your house so that you know what's in there. And that will help you immensely if you have to report a claim. The fourth thing is not having contingencies. Good estate planning says what happens if a child predeceases me. All right. If it goes to my grandkids, well, I don't want it to be controlled by a son-in-law or a daughter-in-law. I want my other daughters, my aunt, there'd be the aunt to manage the money for the kids. I worry about son-in-laws. I really do. We were talking about that before we started this presentation. I don't want them to manage the money for my grandkids because son-in-laws typically remarry really quickly, and I don't want them commingling money. I want someone else that is managing the money. What if a spouse remarries? You got to be very clear with husband and wives. Does the survivor get it all, and can they do anything they want? That's a very important question to ask on the very beginning. What happens if a child gets sued, files for bankruptcy? The beautiful thing of a trust is a trust says, wait a second, if you're being sued, this money is protected. It is not going to go to your creditors. So planning through those things, that's really, I think, the benefit of talking to an attorney as being a sounding board, because we're just third parties. We're just kind of saying, this is what I would do in this case, and there's no say right or wrong. Every family has different goals and different family dynamics. So those are the four biggest mistakes. What I wanted to mention about charitable giving is three quick things. First, if you're over 70 and a half, you can actually do a qualified charitable deduction. What that means is what a lot of people do is let's say they take out $10,000, they put it into their bank account after taxes, it's 7,000, then they give it to a charity. Well, a qualified charitable deduction is you can take that 10,000 and give it directly to, say, the Center for Christian Studies, and there's no taxes. So, in essence, you're giving less to the government and more to God. And I'm a big fan of that. Okay. And that also works for required minimum distributions. If you turn 73, you have to take out money. The government says you got to get that money in your name, and you can actually have that directly sent to the charity. So, again, if you don't need the money, you can just give it to the charity and they're giving more. Okay. Very important. You kind of have to work with your financial advisor here to kind of set this up and get this going. But above all, if you leave money to a charity, it's very important to specify what you want the charity to do with the money. They have different plans. They have different things, and it's okay to talk to the charity. Say, hey, what do you need the money for? Maybe just general administration might be the best use of the money, but a lot of people, I think, are impacted by charities and the work that they do, and they want to see that work continue. So maybe you're impacted by a widows group and you want, say, your church to focus on widows group. So just giving them some instructions, they love that. I've talked to a lot of elders that are like, well, we got this money, we don't really know what to do with. So just giving some of that makes a meaningful impact and carries on kind of a legacy of things that are important to you. Now, last thing I wanted to mention, if you want some more bonus material, I started a podcast called the Hearse Chaser Podcast Show. You can find it on YouTube, Spotify, and I talk for about 20 minutes on different topics. Like episode 2 is how to be a good power of attorney. A lot of people are named powers of attorney, but they have no idea what that actually means. So I kind of have some episodes. We're kind of doing 1 or 2 a week. And if you want a more deeper dive into a certain life stage, we have our Hearse Chaser Academy. If, for example, I have a 2-hour course on losing a spouse, what are things you need to know? Retirement years, there's one there. Blended families, just things that I think just a master class on those topics. So hearsechaser.com is where you can find those things. So I'm right at the time I told Keith I'd wrap it up at 6:55. I just want you to know I really hope that this helps give you some things to think about. The idea you can make a better tomorrow for your family by doing something today. I think a lot of people say, it doesn't really matter when I'm gone. And I think they just mean that jokingly. I think most people really care about what they leave behind. And most people want to give peace of mind and not a mess to their kids. And that's really what good estate planning does. So I thank you. Hopefully this was helpful to you. If it was, share it. And we really appreciate it. So now that we've gone through the presentation, we wanted to leave questions and answers at the end in case there were questions. We didn't want that to be public, like on the website, because we were going to host that. So if there were any questions, this is the best time to roll through those. Turn back to you, Keith.
Yeah, thank you, Stephen. Thank you so much for this. It was really wonderful. Since we were muted, you don't get the feedback for the humorous things you said. So, yes, we were laughing, of course, during.
That's okay. My daughters, they don't laugh at my jokes
Oh, okay.
either.
So you're
So
used to it. Yeah.
yeah.
It's like, yeah. Yeah, I appreciate their names, by the way, introducing us to them. And the Hearse Chaser is just gold. So, very good. What we'll do is, yeah. So as Stephen mentioned, we're gonna we have recorded his presentation here. We're going to have this on our website. So if you're looking at this here live and see you want to recommend this to someone else, please do so. We'll be posting that soon. And if there are sensitive questions that you have that you don't want on our website, we'll certainly be editing those out of what follows here. But yeah, we have about 5 or 10 minutes. So who has a question? Go ahead and I think speak up.
Stephen,
Yeah.
what does it generally cost somebody to set all this up?
Oh, that's a great question. My intake team gets that question all the time, and so the kind of the way that we've coached our intake team when people call and ask that question is to kind of respond with, well, it kind of depends on like what your needs are. For example, if you said, how much does a car cost? I'd say, well, it really depends, right? There are motorcycles, there are trucks, there's, the family van, they have different price points. So that's my general response. But I'll kind of give you a ballpark just to be fair. I think most people fall into like two categories of estate planning. What I would call like simple estate planning. Maybe they do beneficiaries a will power of attorney package. And those price points are probably going to be somewhere around, I don't know, 800 to 1500. I think that's fair. When you're working with a trust, it kind of depends if you're doing a revocable trust versus an irrevocable trust. I would be very cautious if a law firm doesn't charge at least 3,000 to 3,500 as like the base. And it kind of goes up from there because if people have complex drafting or lots of deeds, it can kind of go up. I think ours sits around 4,000 to 4,500. I think if your price point on a revocable trust is under that 3,000, like $2,500, then they're probably cutting corners, and that's scary. I don't know that this is an area of law where I want to cut corners because inevitably, if you have a plan that isn't well put together, then the kids are going to get mad. And so I tell people, I'm 40, I'm going to outlive most of my clients. So I really want this to go well. And I think people, when they understand the value and the little extras that we do, can really help with understanding that value position. So I think 1,500 to 800 for a smaller package trust are probably around 3,500 to 4,500 in most cases, which significantly less than dealing with probate, which can cost you 7 to 12,000, significantly less than dealing with a guardianship, if you didn't have a power of attorney. And yeah, it just what is it? The ounce of cure is better than a pound of prevention is worth an ounce
of prevention worth a pound of cure.
That's the one.
Okay, I have a question. What's the difference between the revocable and irrevocable trust?
Great question. I will say that I put a whole Hearse Chaser podcast show on that topic because I get it all the time. So it's like 25 minutes. So I'll give you the short version here. When someone says they want to protect assets from the nursing home, that's an irrevocable trust. A lockbox. Let's just call it a lockbox. A revocable trust is like a bucket. You can put assets in the bucket, take assets out of the bucket, no asset protection. So if somebody has, say, $3-4 million, they're not really concerned about the nursing home cost because they're self-insured. So they're not going to be doing an irrevocable trust. My common clients, most of my clients in Arkansas have a paid off home at about 100, 200,000. So they're very concerned about losing that all to a nursing home. So the clients I'm looking for are early 70s. Most of their assets are either in real estate or cash. because I can't, like an IRA, if I put that into a lockbox, I have to pay taxes. So you have a $100,000 IRA, to put it in the lockbox, I lose 30% because I got to pay Uncle Sam. So I'm looking for what's called unqualified money, like cash, CDs. So if I put that in a lockbox 5 years before you go into a nursing home, it's protected. So knowing the average person goes in a nursing home at 79, I like to do it early 70s. Okay. I'll tell you that the number one statistic that frustrates me, I see a lot of financial folks say 70% of Americans will need long-term care services. And you might think, oh my goodness, 70%. Well, that's like in-home care. That's like rehab if you have like a knee replacement or something, assisted living. That's the whole gamut. People are concerned about the nursing home. That's only 17%. Only 17% of Americans really go into long-term care for like 2 years or longer. So I'm concerned about histories of strokes, Parkinson's, and dementia. Those three are the things that scare me. Those are considered the pocketbook diseases. So if there's a family history of that, if there's an early diagnosis of dementia, then we're probably going to do an irrevocable trust and hope we can get past that 5-year look back period. That's a shortened version. There's 25 minutes, I think, online that I think kind of summarizes that.
Okay. Yeah. Thank you.
So that's a good question. I get that a lot.
Anyone else?
I do want to say some things that my firm does that I think really makes the process go well is making sure the documents are scanned in before we give the documents back to clients. So they keep the originals and we send them a copy of the documents, but we keep a copy on file. It's so important. I can't tell you how many people have lost their documents. They've traveled out of the state and they're in the hospital somewhere, and we fax those documents. Having those where we can access those and answer questions, because clients will ask you questions 7-10 years from now. It's helpful to have those in our file so I can look at what they're looking at. So making a copy of your documents very, very important. Sending a copy to your kids. You got to be cautious. If you put all your eggs in one basket, right, in that trusted kid, I may have my middle daughter as my trustee. She might be the only one left, right? So I want her to know where those documents are. I want her to have a copy of them as well. I can't stress how important it is just to make copies. In today's age, that's all you need is copies. You don't need the originals for much of anything. So.
Very good. Anything else before we wrap it up? All right. Well, I think we will call it a wrap. Thank you so much, Steven McClelland, for this very informative presentation on estate planning. And I recommend certainly to anyone listening to this who's in Arkansas, if you have questions or you don't think your estate plan is in order, to contact Steven in his office. And I thought it was really good advice for those outside Arkansas to check out the SELA database for a trustworthy advisor and attorney on this. Or contact the Center for Christian Studies, and we'll do our best to help you if you're not in Arkansas. I really appreciated not only how helpful this will be on many scores, but also the charitable donations as well. Even a shout out to the Center for Christian Studies. We have received some gifts from people in estate planning, and some who have specified, as he mentioned, and some who give to the general fund. But these are important matters for us to consider. So thank you, Stephen, for helping us think through these matters.